Good afternoon or good morning or good evening, depending on when you're watching this video. I would like to discuss a couple of upcoming changes that haven't gone into effect as of yet, but will be going into effect for one, July 1st, and for the other, June the 12th. And the first will relate to some changes to guardianships through at the Supreme Court. Uh, they're not proposed changes, they are changes that are going to take effect on July 1st as they relate to guardianships. Then the other will relate to what the governor here in Ohio signed a couple of days ago as it relates to what is called constitutional carry. Even though I don't do a whole lot as it relates to firearms, I believe it's probably worthwhile to discuss at about a 50,000 foot level. But as it relates to guardianships, that those are things that I know a little bit more, quite a bit more about, and that's the real point of this video. So I'll start out talking about some rules changes in guardianships, and along the way you'll probably pick up on some of the other requirements, but also at the very end, or the last half or maybe third of this episode, I will talk about the constitutional carry. So this is an article from the Ohio Capital Journal, and the Ohio Capital Journal, this is an article that you can actually get the citation to it at the very end. I'll provide a list of everything I used for this podcast, for this episode, so you can independently read. But essentially, all this is saying is, the Ohio Supreme Court is making these changes to help fight fraud and abuse, and also to encourage relationships with, in communication with individuals, not the ward. So essentially, it's a good summary, but just like anything, this is a news report. If you want to know what changes, we really are going to have, it's good to go straight to the rules. And for that, I am going to, these are the actual rules of superintendence that the Supreme Court did promulgate, or they will apply to all of the county probate courts. And I'm actually going to interact with this. That way we can kind of go over this together. And I'm going to zoom up and let's see. So we'll see here it does take effect on July the 1st. It's going to be the effective date of these amendments. And I'm going to zoom out just a tad. That way we can see this a little bit more. But the real fun actually starts, here in the general responsibilities of the court in establishing a guardianship. We'll see here that the probate court division shall do all of the following. So shall means they have to. So all the probate courts across the state have to do this, and that'll be direct the court investigator to inquire into the visitation history and preferences of the prospective ward during the service of notice of the initial application for guardianship. And just so you know, what they're talking about is whenever a person applies to become a guardian, the court investigator is involved. They will go and actually give the proposed ward, the person proposed to be under a guardianship, the actual guardianship application and notice of the hearing, and then generally talk to the person, see if they are in agreement with things. Do they not like the person who applies? Do they want counsel? Sort of those things. And ultimately, the court investigator, their job is to also sort of recommend. Do they think a guardianship is needed? Do they, what will they provide about the proposed guardian? They can give recommendations on what they think about a person applying for a guardianship, but ultimately, if someone is competent, or if someone doesn't need a guardianship, or the suitability of a guardian, that's for the magistrate or the judge to determine, not the court investigator. But here, this is directly telling the court investigators, again starting on July 1st, that they have to ask these proposed wards about their preferences on as it relates to visitation. So that's that's certainly a change, and also to inquire about those who actually wed. So that's a little different change. I've never, you know, me as being a practitioner, I've never, you know, I always know who's around them because a good family and friends support system is it's always important. So I generally know that, but this is going to put more responsibility on the court investigator, and ultimately it'll make better decisions. You know, the probate court will be involved a little bit more on visitations. It's certainly not a bad thing. I talked at a very high level about some of the requirements for a guardian once they're appointed, and that's education. So we'll see here a list of things that the guardian has 6 months after appointment to take an educational course on it. Again, it could be done for free on the Supreme Court website, but it's not saying abuse has never been talked about. I think most probably did, but this is one of those explicitly. Some of the educational requirements will include abuse, neglect, and exploitation, um, and also how to report, any of those issues. Now, a little spoiler alert by 30 seconds, there already is a requirement to report. It's just expanding on a guardian's responsibility to report. So as it relates to communication with the ward, again, the only changes are the things that are highlighted. And it says the guardian is encouraged to identify those persons with whom the ward desires to communicate and facilitate that communication the guardian believes is in the best interest of the ward. Now, the best interest of the ward, that is the most important standard, the most important thing that any guardian can do or consider is what is in their best interest, and that is a standard that the probate court might even seem obsessed about, but that's the way that it should be. But I would assume even without this change, who the ward has communication with, their individual relationships, and the ward's preferences should always be considered when making a best interest determination before or after these rules, frankly. But here, the guardian shall do all of the following: encourage visitation and communication with the ward, so long as the visitation and communication is in the best interest of the ward. I don't think that means pay for a plane ticket to go halfway across the country in order to allow someone to see the ward. If you were going to use the ward's money for that, you need the court to approve it first. I might allude to that very briefly on some fiduciary responsibilities in a guardianship, but you certainly should say, I'm not going to tell the nursing home to deny phone calls from people that I know this person should be able to talk to. I'll even go as far as when I'm the guardian, make sure they've got cell phones, if they can pay for it, obviously, as long as, it's reasonable to do so, especially if there's no telephone service, or you've got to have a phone call in front of everybody else at a nurse's station, or you've got a shared room for your ward, and he doesn't want people overhearing what he's saying. His cell phone can be important. It's also important that other people know what's going on, because the guardian's not the only advocate. Promptly submit a list of names to the court of any persons or entities whom the guardian has excluded or seeks to exclude from visiting or communicating with the ward. I don't have that issue now. I've had guardianships in the past where I was the guardian, where it was recommended that certain people not communicate. That wasn't my call. It was ultimately, concerns from the court and concerns about, some people that did some unsavory things to a ward of mine, and those people trying to bring that type of influence to wherever he was or she was. I won't give that up, but I can see situations where you want to deny certain things, but the other part of that would be how public is that going to be? It's just how when you have a will, or estate planning documents of the ward, the court needs to know about those important documents. And I think that I don't know if that form is public or not. I'd have to look, but my suspicion is it would be. There might have to be some discussions about, can we make certain records confidential or not, and can you make certain records confidential on your own motion? I've made up my own motions a whole lot in my time, and um, just because there's no court form doesn't mean it can't work. But that list of people to deny, um, I wonder if that'll be confidential or not. Um, so promptly submit a name. So again, what does promptly mean? I don't know. There was something in here about the complaint process. At least I thought I didn't see it. Here, yeah, establish a process for submitting in electronic format or hard copy comments and complaints regarding the performance of guardians appointed by the court, including actions of the guardian in denying a request of a person to visit with the ward. So this is expressly saying the complaint process is appropriate if a person is being denied visitation. And when you file a complaint, it doesn't just have to be the person under guardianship. Let me read that again. Yeah, it doesn't say complaints of the ward. So people who are being denied visitation with the ward likely can also file a complaint as well. And I'll show what a complaint form looks like. But the complaint form, how it works is once it's filed, it'll go to the court investigator. The court investigator will, as the name would say, do an investigation and make recommendations. And then the court, the judge, or the magistrate can decide how do they want to handle the issue. They might do nothing. They might have a hearing. They might, take immediate action. They could remove a guardian after a hearing. So ultimately, it's an instigator of a process by filing a complaint. And maybe nothing will happen, but that will more than likely be a public document at the same time. And at least all the ones that I've seen, or where they've been in cases I've worked on, they're public documents. So I think anybody can see what those complaints are, including the disposition. And okay, so now I'm going to go to just at a very high level, since I've sort of alluded to this stuff. I think it wouldn't be fair for me to not also talk about some of the requirements of a guardian. And as we'll see here, some of the requirements include, making sure that all wills are preserved, that a ward might have, file it with the court. When it comes to an inventory, also include important legal documents such as powers of attorney. We'll also see here, prepare and file reports. Those reports include an annual statement of expert evaluation, and after certainly the first year, any years after that, if you get a doctor that says the situation won't improve, they can do what's called dispense with the reporting requirement. But also, this sort of makes sense. It's to comply with the orders of the probate court. As a guardian of the person, you've got also some reporting requirements as it relates to doing an annual plan and a guardian report. It's also to make decisions, again, it sort of makes sense, that are in the best interest of the ward. If the ward is moved to a more restrictive environment, make sure the court gives pre-approval first. If they move, make sure you let the court know. I think generally that is 10 days. And those are guardian of the person. Also, when you've got the guardianship of the estate, just hit on these real quick. Some of the requirements are do an inventory within 3 months, do an annual accounting, keep track of where every single penny goes, but also more, just as important, make sure the court gives authority for every single penny that is spent. I mean, every single penny, because that accounting has to be done every year. So ultimately what's going to happen is with these rule changes, it's going to add you know, give a list of people who shouldn't be around the ward will probably be included in this, if any exist. So I'm going to guess these are going to be updated on the fiduciary acceptance to discuss, um, to turn around and discuss the um, the requirement about letting the court know about denials of visitation. So this now here is what the complaint form does look like. And again, this is a standard form. This is here in Franklin County, and it's very, very straightforward. You know, the name of the ward's address, the ward's phone number, and then the complainant's name. So the person filing the complaint, and let me interact with this here. So then we'll see, again, it's in relate to Superintendent's Rule 66, and then the complainant's relation to the ward. So you see it's not limited to just the ward and also the guardian. The guardians can file complaints too. But then what's the complaint? You know, could be denying visitation, or I want to see so and so, they're not letting me see so and so, or the guardian is preventing me from seeing so and so. Desired resolution, I want visitation. Additional information. Then from here, it's filed with the court, and then it goes to the court investigator. So we'll see here that the complaint shall be placed in the corresponding file and a copy sent to the guardian. The court shall then consider the complaint and take appropriate action, and a copy of the complaint's disposition will be sent to the complainant and the guardian. So I would say that's pretty sufficient. That's at a very high level how the process works. And the complaint process, it's there to provide, as I would say, positive reinforcement on a guardianship. So if a complaint's filed, don't automatically assume that someone is in the wrong. The more the court is involved, generally, the better things go. So that's how I like to look at it. Okay. I've already talked about that. All right. So now we're going to shift gears here a little bit, and I actually intend on keeping this fairly straightforward. I don't want to get into all of the bells and whistles. Sorry, dispatch. Again, this, as we see here, this is still the article. This is, I'm sharing the website right now, but Governor DeWine signs into law eliminating the requirement for concealed carry permits. And essentially what this is going to do is, for everyone who is aged 21 or over, that is allowed to carry a firearm, is able to carry so concealed, carry the firearm concealed. Now, and I have kind of thought about this, what is an easy way to sort of understand this, and you can explain it a lot of different ways, and I've got some stuff to share with you to kind of make that point. But essentially, we're already an open carry state, and we've got the CCW, so we've already got those in place. Now, the constitutional carry is right in the middle. So, if we go look at people that are able to open carry, are they allowed to carry the firearm? That's the basic question. And Ohio is, and there are a lot of moving parts on that, but generally, if you don't have a reason that says you can't carry a firearm, such as pending charges, domestic violence, under the influence of drugs or alcohol, those types of things, again, I think relying on, certainly rely on the law, but a good point of reference is actually the Attorney General's, Dave Yost. He's got a pamphlet, and I can show it, about concealed carry, and it goes through kind of a lot of things that can prohibit you from being able to carry a firearm. So we've already got the open carry. So I think the question ultimately is, if you can open carry, and so you're allowed to open carry, in some places you can't. Again, refer to local, refer to signs on doors, and you should be aware if you are going to carry what places you can't carry a firearm in. Don't take it from me, look it up yourself. But then you can conceal carry at the same time, even without a CCW. Now, that'll take effect, I think it's with 90 days, because this law won't take effect for 90 days. It'll be June 14th, June 12th. So up until then, if you don't have a CCW, you can't carry concealed. But I think the whole, what is really changing, I think we really need to kind of understand. We've already got the CCW, so the people have the CCW, that's not changing. And Ohio is a shall issue state, so if you meet the requirements for a CCW, you can get your CCW. If you don't have a condition that says you can't carry a firearm and you pass a background check, you get your CCW. Open carry, you don't need a background check, you don't need a license, but are you allowed to carry a firearm? Do you have one of those limitations that prevent you? Domestic violence, recent, there's several, it's kind of long, but do you have like a crime of domestic violence? Are you under the influence? I don't know, when I say felony, I don't know the extent of that, but if you aren't prevented from carrying a firearm, you can open carry. The concealed carry is just mushing those together by getting rid of the requirement of, the training and the background check. You don't need a background check or a license to open carry now. So, and you never have, at least not in my memory. So I think when we see some people talking about how horrible this law is, I think we need to realize, what is it really doing? I think if you would really be getting a lot of the Second Amendment arguments if you got rid of open carry, because that's already there. So Buckeye Firearms, they did a good job at writing, I think they were involved with this from almost the very beginning here. In this article, it does say it'll take effect in 91 days. And if you might wonder, why is it 90 days? Every law in Ohio, unless it goes through a special legislative process, will take effect in 90 days. Essentially, it has to be an emergency, and I think if it's an emergency and it takes effect on day one after signature of the governor or an override, which I think actually the veto override for the governor and the emergency legislative procedure, I think it's both the same rate. I think it's 3/5, 60%. Don't mix that up with the federal level, which is 2/3, which is 66%. Just know Ohio supermajority is 3/5, 60%, not 66. So it's actually lower. But this was not an emergency, so it takes effect in 90 days. But this article goes on and says, this will not in any way affect those who already have a CCW. The license will be optional, but those who get the license, the CCW, they can still get the background check. It's got to go through, fingerprinted. It's not a BCI. It's one of those background checks, but it goes through various things. You got to show your training, and then obviously you got to pay for the license. And again, Ohio is a shall issue state, so you meet the requirements and you're allowed to carry a firearm. You can carry a firearm. Essentially, that's the same thing as the new open carry, the new concealed carry. The constitutional carry is if you're legally allowed to carry a gun, you don't need a license. And I think that is the talking point that a lot of people are missing in a lot of the things I'm hearing about this. If you can legally carry a gun, even open carry, and you meet the requirements for a CCW, but you have not gotten a CCW, you haven't gotten a background check and you haven't been fingerprinted, that doesn't mean you can't carry. To show if you can or cannot carry, I think the way to go would be if you go and purchase a firearm, try to, and they say, nope, you can't carry a firearm, I bet you that's probably a reason you can't carry one. And I have pending charges. I have pending domestic violence. I have a civil protection order against me. If that's the case, you can't even open carry. And if you can't open carry, then you can't get a CCW either, and you can't conceal carry under constitutional carry. So I think it's important to realize what this law actually does. Again, we're a shall, the sheriff shall issue. They don't have a choice. If you're eligible, you get it. If you are permitted to carry a firearm, you can carry it concealed without a CCW. If you get caught with a concealed firearm and you have one of those issues, you just broke the law. And that's the same with someone with a CCW. If you have one of those things, you're going to lose your CCW. If you're carrying with a CCW and you've got those issues, you just broke the law if you're carrying a firearm. So I think it's important to know what really did change. It's the same rights and responsibilities, going back to this article, the same rights and responsibility apply in either case. It's not changing. It's the same thing. It's not changing. Now, there's some gray areas. I can get to that in a second. But also, this law does, what will go effect on June 12th, you must, the current duty of promptly informing law enforcement that you've got a concealed firearm. Now it's, you may disclose that you've got a firearm, and you have to answer if you're asked. So that's getting rid of the whole, how quickly do I let them know? On a personal level, I think the sooner this is not legal advice, the sooner you tell law enforcement that you've got a concealed weapon, probably the better, especially if you are, obviously, if you're carrying it legally, again, under open carry, concealed carry with CCW, or the constitutional carry, if you are able to carry that firearm and you don't have one of the things that prevent you from doing it, that's not a crime. But if you, are, but if you are carrying that firearm and you're committing committing another crime, that's not an excuse to say you're legally carrying. Just so you know, it's not a gun crime. It's maybe you've got it, carrying out an offense. Again, how about you just don't commit the offense to begin with? That's just a little bit of, maybe that's not legal advice. But you don't have to notify the officer immediately. Then another change would be you don't have to carry your CCW on your person now at all times. Again, I'm not going to hide around the bush. I have my CCW. And when I'm carrying, I always know I got to have my CCW license with me. But starting on July 1st, it makes sense. Why should a person who doesn't have a license be allowed to carry? And not, they don't have a license either, but the person with the CCW that forgets their CCW license, it's the size of a driver's license, they just committed a crime by, having the CCW but not having it on them, but carrying. But if you don't carry it, you don't have it, but you are carrying it, and you don't have a license, you're fine. Did you catch that? So I think that makes intuitive sense here. Okay. So, the next thing I want to show is, this is a wonderful booklet. And, and I had said there's a lot of overlap with open carry, constitutional carry, and the CCW. There's a lot of overlap. I'm even going to assume the Attorney General is going to update this pamphlet about this. But wonderful resource. It goes through, what things might prevent you from getting a CCW. Again, just because people will have the right to carry a concealed weapon without a license doesn't mean they are correctly, or that they are permitted to do so. And if they are caught having a concealed firearm, but they don't meet the requirements that even a person with open carry or a CCW, those requirements take away the actual licensing and take away the actual, the fee and the background check. But if you fail some of the other requirements, again, no domestic violence, no civil protection order, and those things, you've got a problem. So ignorance is not an excuse of the law. But some of the big things that I at least think are, I don't know the answer to these things, but what I do know, and I've read it on a couple of things, that this constitutional carry will apply within the state of Ohio. So how it works now, if you have your CCW and the Attorney General of your state and another state you're in, if they have a reciprocity agreement or settlement agreement, I'm not sure what they call the heading of that, but my concealed carry will be recognized in almost every state I go to. And the ones that don't, I know what states they are, and I know what I got to do so I don't break their laws. But the constitutional carry um, won't cross state lines, from my understanding. There is that possibility that another constitutional carry state you won't have a problem with, but it does mention residents of Ohio. So residency has a defined term. Residency means the intent to live somewhere indefinitely. So if let's say Kentucky has that, I don't think Kentucky's a problem, but let's say they had said it doesn't apply to people that are not residents of that state. Well, if you're not a resident of that state and you fill that definition, you might have just walked into a problem. But to be safe, the CCW is probably the safest bet to cross state lines when the other state has a reciprocity agreement with the state of Ohio. So I don't look at this as exceeding the border of Ohio. So movement within the state of Ohio. I also want to talk about another kind of gray area, and this pamphlet goes into it. If you're under the influence, and I don't care if it is open carry, I don't care if it's concealed carry with a CCW or constitutional carry, you can't carry the firearm. You can't. And it's not changing anything. You can't do it. So if you would be a new carrier and you're like, I don't have any of the domestic violence or offenses that preclude me from carrying, the alcohol thing is a big deal. But with a CCW, you are able to be, let's say, in a bar where other people are drinking, as long as you don't drink. What I don't know, and I'm not, this is again not legal advice, but something you need to know the answer to, is does the constitutional carry permit the person in the bar who is not drinking, but people in the room are, can they carry the firearm concealed, as long as they're not under the influence? I don't know the answer to that. That's something, I don't have to worry about. I have my CCW and I know the rules, but the alcohol is a big deal. The firearm in the automobile, I do know in the state of Ohio with my CCW, I can do that. And, as long as I'm not under the influence, again, I shouldn't be driving anyways, if that's the case. But, how does transporting a loaded firearm within the cabin for someone without a CCW, I don't know the answer to that. Again, something to flesh out, and it'll change over time, and I'm assuming this pamphlet will talk about that. I'm sure Dave Yost, he does a good job with these things. He'll talk about those. But ultimately, this is a cautionary tale. With the new law, I wanted to be, what is really changing? Are you going to have more people concealed carrying? Yes, it's going to happen. But will someone think, oh, I'm fine, I can concealed carry, it's constitutional carry? When they say constitutional carry, I don't think it's constitutional carry. It's just what they call it. But there are limitations on it, and if you don't realize that you are not in compliance and you are not allowed to carry the firearm, and you just broke the law. So cautionary tale. And if we're going to have, some more firearms, people carrying concealed firearms, and maybe, new, people that are going to have firearms for the very first time, it's going to happen. And one thing I haven't talked about, this relates to carrying a firearm. What I didn't say at all, I didn't say anything about having a firearm in your home. Again, that's for another day. But the home is different. When you're carrying it outside the home, that's a completely different ball of wax. A benefit of the CCW, I will say this, is you have to go through a background check. So it's an acknowledgement that you don't have any of the disqualifiers if you've got your CCW. So if you go and purchase a firearm, With a CCW, it would be easier, to be honest with you. And if you've turned around and violated the terms, you're going to lose your CCW. Let's be honest. If you don't have your CCW, you can't turn around and get a firearm without a full background check. So that might concern some people that someone with a CCW might have a shortcut, but if they lose the privilege of a CCW, they couldn't purchase a firearm anyways. You see what I mean on that? And then if you don't have the firearm, you would be caught up on the initial background check anyways. And if you don't have your CCW, then that means a background check is needed. So I don't think it's as bad as some people might think it is. But that's one of the benefits of continuing with the CCW. Cross state lines, you don't have to worry about those gray areas, and the background check's already done, fingerprinting's done, and you've got your training. And frankly, if you are a constitutional carry, you should know your firearm. And if you don't know your firearm, you probably shouldn't be carrying it anyways. You need to know how it works. But certainly people need to know the laws in Ohio, especially as it relates to self-defense. Ignorance is not an excuse to the law. That is more than likely legal advice that I'm willing to give you. But just keep your head up and know what you're doing. Be educated on this stuff. Ignorance is not an excuse. And you're in Ohio, so what does Ohio law say? I don't care about what other states do, and neither should you. How are the laws in the states you are in? The state you're traveling to, what does it do? Going to Washington, D.C. is not Columbus. Going to New York is not Columbus. Going to Chicago is not Columbus. Going to Florida might be similar. Going to Texas might be similar. Going to Kentucky might be similar. Virginia is slightly different. You got to know the jurisdiction. It's not an excuse to say, well, Ohio is this. And that, by the way, is the exact same thing as it relates to self-defense. Self-defense in one state is not the same as another state. So if you see on the news, well, that was self-defense. Well, that wasn't self-defense. Doesn't matter. What does the state say that you are in? That you have to exert self-defense. You need to know the laws in those places. And if you're carrying a firearm and don't know those things, just not knowing the law is very, very dangerous. So I recommend doing your research on that. Okay. So I know a lot of people that are watching this, and probably a lot of you are like, "Whoa, yeah, Ryan, I knew all of this. Why are you saying this?" Well, we might have some new firearm owners in the state of Ohio, and new people carrying a firearm, and it's just like anything. You get a car for the first time, you might be so excited about driving off for the front. Remember when I was 15 and a half when I got my temps? You're so excited, to drive that car for the first time. You do a little bit of property damage in your backyard while you're backing out, in front of your house. You don't know the bells and whistles. You don't know the mirrors until you know you need to use the mirrors. It's all, guidance until it's not guidance anymore. But with firearms, it's not as forgiving. So we've got the 4 basic rules of firearms that everybody should know. I mean, absolutely everybody should know this. Every firearm needs to be treated as if it is loaded, always. Even if you are, have no magazine in it, even if you are pretty sure, because you just cleared the chamber 3 seconds ago, even if you're pretty sure that the chamber is clear it again. Never assume a firearm is not, never assume that it's unloaded. Incredibly important. And this is incredibly important when you're cleaning a firearm. You got to make sure it's unloaded. You have to. Take steps, and while you unload it, make sure you're following the other rules as well. Never, ever, ever point a gun at anything that you're not willing to completely destroy, dismember, obliterate, kill, whatever you want to say. If you're not willing to completely destroy it, even if you think it's unloaded, don't point it, period. Ever. Don't point it. Yes, even if you just cleared the chamber, just don't make it a habit of ever pointing a firearm at something you're not willing to completely destroy. Keep your finger off the trigger always, even if you know it is empty, even if you're not pointing at anybody. Make it a habit. Never, ever, ever put your finger on the trigger unless you intend on pulling it. Yes, never, ever, ever do that, even if you know it's unloaded and nothing is in it and nothing is in the chamber. And always be aware of your target and what is behind it, because usually you're not going to hit one target. You're going to hit the target that is behind the target that you're looking at. So know the target, and this is all even important, when you're at a gun range, testing out a firearm for the first time, cleaning it in your house, but also even if you need it in self-defense. Um, you need to know what's behind the target, because, you know, those are all things that'll become relevant if you ever have to. It might look like you're a little reckless, and that's probably not good. So make sure those 4 rules of gun safety. And maybe I'm not teaching anybody anything. You might be more experienced with firearms than I am, but these 4, every single person should know. And just for the record, I'm against Nerf guns and water guns, play guns, all of those, because it makes kids think that firearms are toys, and they are absolutely not toys. Even the toys, I don't want kids to think they're toys. So that's, just me, being a father. Okay. So the very last thing I want to show is I've got a list of all of my citations, of everything that I talked about here. I'm about 41 minutes into this, but everything that I talked about, with the exception of showing my actually, I didn't show one thing. I do want to, let me go back. I want to share one thing that I didn't share. Okay, so we'll see here that this gentleman here, Nino Vitale, he is a member of the General Assembly here in Ohio, and he actually he was my CCW instructor. So I can admit that before I took my class, I didn't even know how to properly hold a firearm. So I want to give him credit for that. But he made a post, and just so you know, he has been a firearms instructor longer than he will ever be permitted to be a member of the General Assembly, because we have term limits in Ohio. In order to have term limits for federal officials, we need a constitutional amendment, which is very difficult to have. We've got it for the presidency, but there are no constitutional limits for members of Congress, or House members or members of the Senate. To do that, even if Ohio wanted to say, governor, I'm sorry, representative, pick who it is, or Senator Rob Portman can only serve 2 terms. Well, no, in order to do that, you've got to have the Constitution of Ohio, of the Constitution of the United States say that, because that determines the eligibility of a member, even if the state of Ohio says, whoa, 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 wait a minute. It doesn't matter what Ohio says, because it's not an Ohio body. Kind of going off tangent here, but I want to read his post. Constitutional carry is signed into law in Ohio, a victory for freedom. Yes and no. It's a little bit more. It just takes away a requirement. It doesn't really change a whole lot. I agree with Nino on a lot of things, but I wouldn't say it's a complete victory, but it's improvement if you are a Second Amendment person. As of June 12th, you no longer need a permit or training to carry a concealed handgun in Ohio. And again, there's some caveats to that. Legislation was signed yesterday to allow people in the state to carry a concealed handgun without a permit or training, and no longer require them to proactively tell law enforcement during traffic stops that they are armed. Senate Bill 215, which takes effect in 90 days, allows anyone 21 or older to conceal a firearm unless state or federal law prohibits them from possessing a firearm. So the people that are open carrying, which is allowed by Ohio, they wouldn't be allowed to open carry if they were forbidden under Ohio law or federal law from carrying that firearm. That's the whole thing. What does it really change? It doesn't change a whole lot. It just makes it where those who would be able to open carry can now conceal carry. Again, carry, I'm not talking about in the household. I'm talking about carrying outside of the house. Ohio will become the 23rd state to allow concealed carry in public without needing a license, and Senate Bill 215 will also no longer require motorists to proactively tell law enforcement about the concealed handguns in their vehicles during traffic stops, though drivers would still have to truthfully say whether they have a gun with them if an officer asks. And again, it ties back to, are they legally able to carry the firearm? It doesn't matter if it is concealed, CCW, or constitutional, or open carry. It's either legal or it's not. Again, I don't think it's a huge change, and maybe Nino would agree with me on that. Even though people will no longer need a license to carry a concealed firearm in Ohio, many state residents will likely continue applying, like me, will continue applying for permits so they can carry a concealed firearm in other states that still require a license. I agree with him on that. And I think there might be some other gray areas that might make it easier to just have the CCW to not worry about it. The bar issue, will it be exactly the same as the CCW situation if you're not drinking but around people that are? And then, you're proactively getting a background check, which might be more of a convenience. Um, but no, Nino, finish it. Stay safe and carry on. And he's got some quotes here that maybe you like the quotes or maybe you don't. I want government so small you can barely see it, and so efficient you barely have to pay for it. And my favorite politician has become the one who's on vacation. They cannot steal my money or take my freedom. It's not me saying that. That's Nino saying that. Constitutional carry is signed into law in Ohio, a victory for freedom. If you're a Second Amendment person, um, there's improvement. And if you are against this, it's not. I think both sides have their talking points, but when you really get down to it, there's not a whole lot of change to this. And that's, I think what the takeaway ultimately is. But if we've got new firearm owners out, the people that want to carry for the first time, make sure you don't have one of those conditions that makes it where you shouldn't be carrying to begin with, because that's a crime, and that could be problematic. Ignorance of the law is not an excuse. There are my citations. I am 47 minutes into this, so again, I talked about the new changes to the guardianship laws, not laws, I apologize, superintendents from the Ohio Supreme Court about, the visitation and the new education, and those types of things. And I think good changes. And then also, it could be with the constitutional carry, it could be a good thing, but it could also be a trap for the people that aren't really paying attention. Don't be the people that don't pay attention. Make sure if you are going to start carrying concealed, you know that there's not a problem with you carrying. So that's not legal advice, but it's strong encouragement. So, without further ado, I will stop talking about substance. The substance seems kind of heavy. I want to thank you all for watching. If you liked what I had to say, share and like and subscribe. I'm relatively new to this YouTube stuff. I do have a Facebook. My firm has a Facebook. Ryan G. Welker, the law offices of Ryan G. Welker. If there's something you want to discuss, feel free to let me know. Again, a lot of my practice area, actually most of it, like all of it, relates to, again, estate planning, guardianship, elder law, long-term care planning, and, like trust, estate administration. And, it doesn't seem like a lot, but it is. But I like to know a lot about a little as opposed to a little about a lot. When it comes to the firearm stuff and the criminal stuff, I know a little about that. I don't pretend to know a lot. That's not a niche of mine. For something like that, talk to someone that practices in that area. But when it comes to the areas I practice, I try to know, stay on top of as much of as I possibly can. A lot of times it depends on, what issues am I experiencing with my clients that force me to know certain things. But either way, if there's anything you'd like me to discuss, just feel free to let me know. And again, thanks for watching.